First, I want to appreciate the complexities involved in trying to adapt and comply with federal law, which is now embraced in California on the overtime. And maybe you're getting to this ahead of us, but with this respect to the exemptions where a provider qualifies for going beyond the caps, and the problems that you've identified of timesheet reporting, and where there are errors in the timesheets, and maybe I think the totality of errors go beyond just these exemption categories. There's other areas, but how are you accommodating if they're nominal errors? To protect the continuity of services and to protect that provider's good standing, is there a way that you can rescind violations once it's corrected? Without getting into too much of the weeds, how are we helping providers to be in compliance in a manner that protects ultimately the consumer interest of not having a disruption of service? Does that make sense? Is that
it does make sense. The short answer is that errors identified always have been and will continue to be able to be corrected in the CMIPS2 system. That's the short answer. The longer answer is on the next two slides.
Okay, so thank you, and I'll wait to see those.
All right. In terms of errors, the implementing state legislation, I'm on page 16, implemented a statutory four-step process for education, training, assistance, and error correction. As I mentioned, we had a statutory requirement for workweek agreements to try to negotiate these situations and help people figure out the coverage plan, if you will, to ensure that they had care. We did informing notices beginning in October of 2015, this time to people. And that effort has continued with training that I also alluded to, and that runs the gamut from how to fill out a timesheet. We have training on that live on our website in video clips. Labor organizations have been out doing this. Counties have been doing this. So there's been a massive training effort that's not described on this slide that runs up to that. Even with all of that effort, and we have great partnership in that effort, but even with all that effort, we knew this would be complicated. That's why the implementing state statute provided a 4-month transition period or grace period that began February 1 and ends May 1st, 3 months after implementation. And during that grace period, excuse me, during that grace period, we've instructed counties to look at the errors that have been made and reach out and help people understand the rules of the program, understand what mistakes may have been made, understand what changes they may need to make in terms of their provider availability, or help them get additional providers and those kinds of things, consistent with what we expected them to do in the workweek agreement. To reach out to them and do that kind of assistance during the transition period, shall we say. Now, I'm sorry, I lost my train of thought completely. No, I got it. She'll help me in a sec. So the way that payroll is done, obviously we started paying February 1 and the first paychecks come in February 15. And it took a while for that data to come in, and not everybody turns them in on day 1, right? So we wanted to have data as accurate as we could. Counties didn't begin until last Friday to receive dedicated lists of data. It's been in the monthly data download. It's been in the monthly data download that we make available to counties that shows which providers made errors on their timesheet that need follow-up. And so that data is made available again in the monthly data download. But the entire month of February passes before that data shows up in the download. So you kind of lost a month, if you will, just in that process. And then only yesterday were we able to make these files available to labor organizations as well for follow-up. And all of them are continuing to reach out to providers. Nobody wants providers to make errors. Everybody shares a goal of ensuring that providers continue to be available to provide services to the recipient.
And should I assume that internal, both the county and the labor organizations are going to do their own kind of training on issues that seem to be systemic, if you will, in terms of errors that are being made in this new process?
Can you talk a little bit about the February Train for Trainers effort and some of the other things that we've done?
Well, yes, Pete is talking about, we did a Train for Trainers program that goes through how to do your timesheet, how to work with the overtime issues. It touched on some of the exceptions and processes that have been going on as we've moved forward, and that is continuing. Counties have done counseling letters that they're sending through this transition period. As I said, we just recently gave labor the same information so they can go out and identify the individuals. So statewide, for both months of February and March, we've seen just under, I think, 25,000 errors in timesheets for those 2 months. So that's like 12.5 per month that we're seeing, which is much lower than we had anticipated. Half of them are on cases that's a one-to-one, and the other half relate to individuals who are working over the 66 hours. And part of that is simply that they're aware of the changes in rules that will go into effect May 1st, but they've chosen to continue to work over those caps because there's a financial incentive that I completely understand and can share.
They're going to work right up to the May line.
Exactly. Right. So we anticipate seeing further behavioral changes beginning after May 1st that we'll be able to work on. Part of the thing I do want to add in here is that violations, the way they're issued and why we look at them as a monthly, is because an individual can only get one violation a month. So say they've made 10, we're only going to give you one. And if you've made errors in the first 2 weeks, you can correct them in the back 2 weeks. Like if you've used too many hours in the first half, you can change it in the second half. The end result at that month is the system will not give you a violation. So part of it is when the counties and when labor are looking at it as we start in May, is this awareness that you can see that people are making an error, but you need to understand that at the end of the month, they have the opportunity to fix it and not actually get the violation. And that's going to give you a different picture in the system every time you look until we do the whole coordination at the end. So going forward in this particular time frame, an individual in May would not get a violation, because we move into that language now, until probably the middle of June. So timesheets have to come in and be processed. The counties have a 5-day period prior to the issuance of a violation to review the case and suppress it. So in other words, it can be rescinded before it's ever issued by the county simply looking in the system. So a social worker will get an indicator that says the name of the person, and they have the opportunity to hit override. And if they do that, it's overridden. If they don't, it goes to their supervisor for another 2-day period where they have an opportunity to say, did you follow up? Did you contact any individuals? Did you try to correct it? Now, if they don't do anything, then it just simply goes into the violations issued, and we go into the dispute process, which has a formal appeal kind of process that goes through for each violation. For violation 1, that's the first one. It's more informational. On violation 2, you have an opportunity, sort of like driver's school. If you get the violation and you choose to sign a document, we'll send you training materials for you to review at your own time and energy and availability, and then return that to the county. And at that point, violation 2 is then rescinded. That's a one-time shot. After that, you get your next one, it's still violation 2, but you can't go back through driver's ed, basically. Violation 3 is where you start to have, and I do want to point out for violation 1 and 2, the expectation is that the counties, and I'm hoping labor, because we're now giving them letters with everybody who's getting a violation, are reaching out to these individuals before we hit the stage where we hit a violation 3. which is really almost violation 4 because we've given you the get out of jail card on violation 2. So when you do hit violation 3, you will have had contact by the county to tell you you're aware these violations are occurring, you're aware that this is happening and how to fix it, so that nobody, for whatever reason, didn't get their mail, things move through a process. A human has talked to them before violation 3 can be implemented. Now, violation 3 or 4, however you want to describe it, then goes into a higher level. There is a state level of review, because now we're talking about program eligibility suspension for 3 months. And then finally, you get to violation 4, and it's a program eligibility suspension for a year or termination. The other thing is, if you don't have violations, every year we'll take one away. So you have the opportunity, if you move through the first year and you get 2 violations and then you don't do anything in the second year, we pull one of the violations off. So you have the opportunity to go back and fix and correct. The other thing I just wanted to add too is that through this whole process, things can be fixed. So if a violation for whatever reason begins out, the counties have the ability to take steps to fix it. So whatever issues come along the way, I know we've had a lot of conversations with labor organizations, what if this happens, this happened. So we've built in through enormous flow charts for each violation where the counties have the ability to address it and fix it. So we think we've tried to make this as usable and teachable a process as we can. Pete, did I leave anything?
Anything left out? I think it's important to note that, as we always have in the program, mistakes are made on timesheets. Oh, I worked on that day and I put the wrong number of hours in the wrong box. We continue to have full ability to have a dialogue with people. We are not assuming that these things are problems, but the system does have this way of flagging those things for follow-up. At the end of the day, we want to make sure that the program rules are followed, the intended fiscal constraints are observed and obtained, but primarily that recipients continue to have someone available to provide their authorized hours. That's the entire goal of this. Generally speaking, outside of this 4-step process for providers at the cap, violation of program rules can terminate a provider's eligibility pretty much straightforward. That's the entire reason that the implementing state legislation for this called for this 4-step education and training and correction and dialogue process to occur. Nobody wants to terminate providers. That's not the goal of this policy. The goal of this policy is to ensure that providers are available as necessary to meet recipient needs. And as Eileen said, people will continue to get paid while this process is going through. As she said, violations are issued on a monthly basis. We need to see all of May's time pay period before in June anybody would even get a notice, their first notice. And then we have all of June before in July somebody conceivably could get to step 2. And all along that way, there's an opportunity for dialogue with people. And because we're talking about providers exceeding caps, we're not talking about 436,000 providers in the program. We're talking about a much smaller number that when divided by 58 counties, with the exception of some very large counties, we're not talking about huge numbers of workload. And yes, it's complicated, and yes, we can do more in partnership to provide clearer instructions and more timely instructions, but we also see that even with today's date on the calendar, we have at least 4 weeks to get to the end of May when we can do a lot to address this issue in partnership with our county colleagues. Some statistics for you on page 18. I'm almost done with this for you.
Okay, it's very helpful.
As I said, we get and these are statistics for the February time period. We processed 1 million timesheets. 21% of them, as the pie chart said, were paid some amount of overtime, and the average number of overtime hours was 98 in the month. We continue to see that 3% exception out rate. That's consistent with historical experience in the program in terms of the 35,000 or so a month that require human intervention. In terms of travel claim forms, and this is up to 7 hours a week of travel for a provider who serves multiple recipients within the same day. We've received for February 2,000 of those travel claim forms, and these are separate forms. These are not processed on a timesheet. And we've only seen 86 errors on those forms, and some examples of those errors are there, including incomplete information. In terms of the errors that we just talked about, for February and March, for providers serving one recipient, we saw 12,000 errors. And for providers serving multiple recipients, we saw nearly 13,000 errors. So that's 25,000 errors that we've asked folks to follow up on with us. We think it's a manageable number, and as Eileen Carroll explained, some people know the rules, and they're just continuing to bill as they always have because that's perfectly legit for them to do, and that may cease. So we expect this number to significantly decline going forward. And then in terms of exemptions, for the exemption 1, which was direct mailed to clients, we've received nearly 1,300 requests. Of those, 775 so far have been approved. This is data as of last night. 331 have been denied. 136 are in various stages of review, and 61 of them have just been received. And while those exemption requests in both exemption 1 and 2 are pending, we won't be assessing the violation. They have been, and because the state is approving exemption 1 and exemption 2, it's our staff that is doing the data entry into CMIPS 2 to show that these exemptions have been approved or denied. So starting after this weekend software update, beginning next week, counties will be able to, do I have that right? Counties will be able to see next week in the system who has their exemptions approved. Exemption 2, as I said, we only announced it April 1st. We have only received 6 requests so far. 1 of them is approved, 1 has been denied, 2 have been identified. There's a U missing, it's unnecessary. Sorry for the typo. 1 remains pending, and 1 it was instead considered for exemption 1, a sample size of 6, but that's the status that we have it at the moment. Questions on that?
Are the exemption numbers that have come in thus far in keeping with kind of the universe that you assumed? Or did you have a sense of how many would come in?
So, again, exemptions apply to providers, and it's for providers at the cap. And for providers at the cap, we did what we thought was a good job, direct mailing for exemption 1. And as you saw, we think about 1,200 ultimately will be approved. We've already had 1,300 applications in. It's probably on par with expectations.
Okay, great.
For this group as well, though, they're also the people who should have had a work week agreement in place, and we think a number of these situations may be resolved with the additional providers that we've seen added to the program in the last few months. So we think there's some accounting for that in there. And then exemption 2, obviously, when these contacts are occurring during the grace period and into the month of May, we think that if the situation cannot be resolved, we expect to receive exemption 2s from the counties describing the efforts they've gone to resolve the situation and explaining why exemption 2 is appropriate. Nobody is being penalized while exemption requests are pending. So we think those steps are robust enough to address these issues. We also have made available information if people have questions where they can direct those questions. We're taking individual situations as they're identified to us and resolving them. So again, our primary interest is protecting a recipient's ability to receive the services that they're authorized for. And so if folks hear of problem situations, we ask that they be brought to our attention. I get them personally, Ms. Carroll gets them personally. We have dedicated people at our office for this purpose, and we will continue to process those as they're brought to our attention. So in all of those things, we think we've done what we can do to address the situation here. And we know it's complicated and we know it's not perfect, but we are here to do our best. And we have a lot of good partners in that process.
Well, let me just start by saying globally that I appreciate the notion of errors versus fraud, which historically in other programs has kind of been a challenge in terms of the perception of any kind of error made in an entitlement program, any of these kinds of programs, that the notion is fraud. So the fact that we are using the language of error, and that there are multiple steps in place to allow for timely correction. So just at the 10,000-foot level, I appreciate that that's kind of your orientation and focus, given the complexity, given the drastic change in policy, all that. So I'm going to tip my hat to you. Let me say that I need to step away. I'm going to hand the gavel to Senator Monning. I'm going to sub 4 for the EITC presentation of their budget hearing. As if sub 3 isn't enough, I want to go sit in on another one. So I'm going to pass the gavel, and you've got a roadmap here in terms of the expectation of, and we asked the panel, Senator Monning, to really summarize their main concerns and what are the primary issues that they feel now need to be addressed by the May deadlines. That's the expectation of the panel that was already communicated to them. Going to hand the gavel to you and I'll be back. But we still have, the department needs to continue.
I don't have very much to add for you. Page 19 just shows upcoming things that are still to come in the program. We continue to provide lists of the providers with errors to counties and labor organizations. June, as we said, we need to see all of May before June happens, so we think there's some time there. And we think September is probably the first time we will see violations 3 and 4. So again, as this number of people that are affected shrinks, we think we have time to address those situations. And we note that the implementing statute requires a report to the legislature on the impact of FLSA on the program overall on January 1, and we can fully intend to meet that deadline. I won't talk on slides 20 and 21 in the deck, but we're often asked what changes were made to the CMIPS2 system to implement FLSA, and those are all described there. And I won't go into that detail for you, but again, happy to answer any questions.
Yes. We are going to go to our panel here in a second, and they may frame some of these questions better than I'm able to, but you've walked us through with some detail when there's violations on timesheet or errors on timesheet or on qualifying for the exemptions. If an error is detected and there's resolution, does that stay on the provider's record if there's resolution, they didn't put the number in the right box, or does that?
Detected in the system, and no, it does not stay on their record.
Thank you. So I think we will go to the panel. I'll let you introduce yourselves and go in the order that you choose. And then I would ask the department, we may have some questions based on their testimony and to be prepared to respond to some of the questions that will, I think, be best if you can we'll let everyone have their chance to present, and then we'll go back to the department for some reactions. Thank you.
Thank you, Mr. Chair. Kathy Sunderling McDonald with the County Welfare Directors Association, and appreciate the opportunity to represent a broad coalition, including counties, public authorities, providers, recipients, and others who've raised issues with the situation that we're in as we head toward May 1st, which is Sunday. I did have a handout, and that was handed out by the sergeant, sir. I'll also share with the members at the table so they've got it. It just extends a bit the timeline that's replicated from the department in your agenda on page 21. I think when you look at the agenda timeline, while it's accurate to the point of May 1st, it makes it look like then we're done. And we wanted to make sure to show there's some additional work, instructions, programming that we still are waiting to have happen, which is a pretty critical point, I think. And the agenda really does lay out the issues quite well, and as has the conversation so far. I just want to hit on 3 really critical points and then talk a little bit about some of the things that we're requesting at this point. So first, as you've heard, instructions and other materials have been delayed, and they are at times still incomplete. And we are certainly not saying that DSS staff have not worked hard. As you can see from our timeline, an enormous volume has come out since January. We've received 8 all-county letters or all-county information notices, but we know that they're not complete yet. There's still 2 draft all-county letters that we're waiting to get. The drafts of those were 36 pages and 46 pages respectively, so they're not small letters that we're expecting to get. And the forms and notices that are being developed or changed are still in various stages. Some are in the works, some are in English but not yet translated and so forth. So we know additional things are going to be forthcoming past this May 1st date from the department to the counties and to the providers and recipients. Second, overall, we think county workers just don't yet have the tools that they need to be able to do the job that's being asked of them. The informing materials have not been made available or sent to all clients. We appreciate on Exemption 1 that there was a targeted mailing. I think until recently, we'd all been under the impression on the coalition that they'd gone to all clients, and we found out more recently that it was a more targeted subset. And at this point in time, there hasn't been a mailing related to Exemption 2. It sounds like that's something that the department is expecting the counties to do as we identify the violations. And while that may be helpful, someone may not have a violation just out of luck in the first month or 2, and then suddenly they have one. Then they come to our attention that they should be eligible for the exemption, and in the meantime, we've had these exemptions occur. So we do think that thinking through how we can inform providers better that they may be eligible for that exemption is really important. And also, so far the CMIPS computer system doesn't have all of the necessary functionality. One example is there are requirements for work week flexibility for someone who normally would not be getting overtime because they don't have someone who's near the cap. They need to shift hours around in a month. We at the county level can make a case-by-case agreement to do that, but there's no way to put that in CMIPS until mid-July. And so we would then have a violation occur. The worker is going to need to remember or go back and research, oh yes, that was the one I approved, keep some kind of manual tracking for those months until that functionality goes in. It's just, again, more work and manual work in this case that we don't think makes sense and could result in people getting errors or having to go through the dispute resolution process that wouldn't have to do that if that had been programmed. And then finally, we do think that there just needs to be an examination of legitimate issues that are being raised with things like the definitions of violations and the definitions of exemptions. My colleague is going to address the exemptions question, but with regards to the violations, there can be very unintentional math errors, and even the order of timesheet processing, which order the sheets get put into the system, can result in an error. Counties can review and reverse those, as Ms. Carroll noted, but they have 5 days to do that per the all-county letter that we just got a few days ago. And it feels like a game of race the clock, to be honest with you, to try to beat that letter getting generated by CMIPS, to get that up the chain to the supervisor, to get the buy-off, to make sure that that letter doesn't get sent. Of course, they can also dispute, but that lengthens the timeframes again, and makes people really, I think, nervous about what's going on with their provider if you're a recipient, or with your own ability to provide services in the program when it really has nothing to do with quality, and it may just be a completely unintentional oversight. I'll say too that we would like to hear more from the department, because it's the first that we've heard that we can correct timesheets in the second pay period and correct timesheets where someone worked too many hours. Those are things that we heard from Ms. Carroll in her comments. Those are not things that we've seen in prior ACLs. We're not sure if that's coming out in the draft now. So that's something that's really important, I think, to explain to counties, because we're not sure. We've just not heard that up until this point. I want to just sort of tackle a couple things that we've heard and just ensure, and I think you understand, but for those listening to the hearing and for the other members, first, the idea that really no one is affected until later this summer because no one can be removed from the program as a provider. I think there's 2 things to say. First is This is really complex stuff. I mean, this PowerPoint alone is really complex, thinking about the exemptions and whom they apply, thinking about the violations. There's a cheat sheet to try to calculate how many hours in a month and then change that to weeks and then change that to your month, because February has a different number of days than March than has a different number of days in April. And so the numbers change. It's one of the reasons why we're suggesting taking a look at that, for example, and converting to a 26 biweekly same length pay period structure like so many other businesses do. And also, violations really matter. People are scared already about this. And so a violation comes, even if it's something that's going to get overturned in a dispute, that's going to take a few weeks to do. In the meantime, people are going to be really upset and really worried. The phones are going to be ringing off the hook. So I think to the extent that we can try to avoid that by doing a little more work up front before those violations really start to toll and those letters get sent out, we'll avoid that heartache and stress for who are our neediest clients. These are the people at the high end of the needs that we're talking about in these situations. The idea that we've had instructions and ample time to prepare, we've acknowledged the receipt of so many letters, and we appreciate the February training very much that happened, but since that time, we've received 4 more letters, and 2 more are on the way. And so the training hasn't been done about those, in particular the exemptions and a lot of the details around the violations, and especially how to get those back out of the system hasn't been trained on. And so while the training was very helpful, it wasn't complete, and more we think is needed before this takes effect. In addition, the data has been delayed. As you heard, the data just got to counties and to labor in the past week, and we don't believe that it includes a list of those who have already been granted exemption 1. It only includes the violations, so we're not able yet to see the actual exemptions and really work with those data until that programming goes in. And it can take weeks for counties to develop and deliver training. Los Angeles alone has 700 social workers and 240 clerical staff spread across 8 offices. So a letter being published is really helpful, but then we have to translate that into procedures locally and get that trained, and that just takes some time that we don't have when we're sitting here on the 28th of April and these violations start to tick on May 1st. Finally, we've heard from Director Lightbourne. He said in the Assembly hearing on this issue that the policy is settled. And I really want to be clear that we're not asking as a coalition to completely reverse the policies, to eliminate the idea that violations would occur, to somehow not enforce people following the rules. What we want to do is just take a step back and make sure that we have time to notify our clients regarding the exemptions and get those processed with the state so the violations don't occur when they don't have to. We're asking for a delay of the violations taking effect until September 1 to allow for that to happen. We're asking for the complete instructions, forms, and the notices properly translated and time to train our workforce on the new rules and requirements. And we're asking for the functionality in CMIPS to take effect so we can support our social workers and avoid unnecessary manual workload and errors on their part. Finally, we really are asking to examine the definitions of violations, the hour caps. There's actually 2 different hour caps depending on if you're serving one recipient or multiple recipients. That's confusing to us, and we think also a moving target. People change their needs. Recipients might add a provider, providers might add a recipient, and then suddenly their cap has changed, and they have to be aware of that, and they have to remember that. There's a few additional requests in the memo. I know you can read, so I'll let you focus on those and allow the rest of the panelists to share their experiences and their concerns. But I do want to say that the coalition really thinks that these are reasonable requests. We appreciate that the department has done a lot to ensure that people are not injured by this, that people are not going to be unfairly persecuted or penalized for this. We think more can be done, and we're just asking for a short delay to make sure that we can do that. And of course, I'm available to answer questions.